Excellencies, ladies and gentlemen, distinguished experts, greetings from Seattle, Washington. My name is Professor Anita Ramasastry. I'm a law professor at the University of Washington. I'm a former member of the UN Working Group on Business and Human Rights and currently serve as the Special Representative on Combating Corruption to the Organization for Security and Cooperation in Europe, based in Vienna. My goal here today is to speak very briefly about the role of the private sector. What role should it and can it play in the fight against corruption, but more importantly, in identifying and returning assets of illicit origin to home jurisdictions, while of course balancing issues of due process and human rights relating to privacy and data protection. Well, the industries that we care about are ones that are called gatekeepers. Gatekeepers include professions like law firms, banks, accountancy firms, real estate brokers and dealers, luxury goods dealers, notaries. These are all service providers that provide the critical link that allow individuals and businesses to move money globally across the world, usually for lawful and legitimate reasons. But often these same professions are used for illicit reasons and purposes, for setting up offshore bank accounts, for basically setting up secret or anonymous shell companies, and for doing things that make it very difficult for law enforcement globally to identify those illicit assets. So while these entities have an important role, they can be misused, which means it is very important for these industries to act ethically and responsibly and to cooperate with law enforcement. What does that mean? It means that policymakers in many jurisdictions are turning their attention to these professions and asking or expanding their laws relating to money laundering and illicit transactions to include these professions within reporting frameworks, creating a duty for them to fill out, for example, suspicious transaction reports. Again, nothing public, all only going to law enforcement and financial intelligence units. But again, sometimes the professions have fought back. But collective action within the industries themselves is very important. The World Economic Forum recently published something called The Roles and Responsibilities of Gatekeepers in the Fight Against Illicit Financial Flows and created something called a unifying framework, and I'll provide a link. This framework has 5 key principles around heightened due diligence, around cooperating between sectors. Real estate agencies should talk and cooperate with banks. Banks should cooperate with notaries, not necessarily to exchange information unless there is a way to do so lawfully, but also to develop typologies and red flags and to identify risk, geographic risk, sectoral risk. What does real estate fraud look like? This is very important, as well as training employees and contractors and others to spot patterns. The idea is that gatekeepers can prevent illicit financial flows from coming into the system, and once they're in the system, when law enforcement has an investigation underway, can identify and detect those funds, and it is very important. So I'm pleased to say that the unifying framework is an initial attempt to address this issue and provide some general baseline good practices for these different sectors. Additionally, there is efforts underway through the World Economic Forum for the real estate sector, and I think construction as well, to pilot and put these principles into practice. The second piece is just beneficial ownership. Beneficial ownership registries, the European Union Anti-Money Laundering Directive, for example, the fourth one, made it a requirement that there would be public registries showing who owns all companies, and not just a shell owner like in a law firm, but actually the true beneficial owner, who owns those assets, who gets the profits. And this is important for investigations because, again, if you can't pierce or understand who owns the shell company, it's hard to identify who owns those for the purposes of asset recovery. Now, the European Court of Justice struck down that requirement of public registries for privacy reasons, and now lawmakers have to think about, well, is there a way to make this accessible for law enforcement, but also for journalists, for media, for investigators who have legitimate needs to see the data. We're seeing a little bit of a backsliding in transparency movements around beneficial ownership. We need to double down now and find ways to make sure that there are registries. And then the question of how public those registries are and how effective the information that are on those registries are things that can be debated. I'll stop there, but I think those are 2 topics I hope will be discussed in the workshop today. Thank you.